Nice to see you all. Get this going real quick. So we are talking about FinCEN, right? So this is a new law that is going to start affecting us as real estate professionals um, March 1st. But I will say it's already affecting us now, because if you have deals in escrow where that are covered transactions, escrow is going to start asking for information and data today, right? They're already needing to do that, because if those deals are going to be closing after March 1st, we're going to need to be in a position to manage the reporting. So I'm going to explain the history of how we got here so you have a sense of what this is. Your clients are going to be asking you questions because escrow is going to be asking them for information escrow's never asked for before, right? Information about their beneficial owners of their trust or their entity, and a lot of financial information, things we've never asked for before. So the consumers are going to be confused, and they're not going to know how to answer some of the questions. So the more that you guys are prepared and can say, oh, this is why this is happening, and these are the tools that you have, and here's where to go to get more information, the better it's going to go for you and your clients. So when we start with the history of FinCEN, this is a division of the Treasury, right? So same people who do the IRS are this governmental agency, the federal government, the Treasury. But FinCEN is a different division of the Treasury. So unlike the IRS, which is focused on taxes, FinCEN is focused on money laundering. Okay, so their job is to try and keep bad guys out of our financial system, impacting real estate transactions. So FinCEN's charter allows them to do 4 things. Okay, the first one is to collect, analyze, and disseminate financial data. So every year they put out reports about how much money is going in and out and what's going on and how many bad guys they caught, right? All of this is part of their charter, looking for and managing the financials of our country. They administer what's called the Bank Secrecy Act, which is what this rule is implemented under. So if you've ever had an escrow, when I'm talking to my escrow clients, I live this. You're having escrow and the money comes in and the bank says, oh, by the way, we got the buyer's money, but we can't give it to you, right? That happens. They are doing their anti-money laundering regulations and checking that money before they can give it to us, right? So the money's there, but they're not ready to give it to us yet because the banks are subject to the Bank Secrecy Act and they have rules about the money that comes in. So there's this thing called OFAC, the Office of Foreign Asset Control, right? OFAC. So every money transmission that comes in or goes out and all the escrow transactions are all submitted through OFAC looking for bad guys, right? So this has been happening, but it's now going to happen at a higher level because of the way this rule is set up. So FinCEN has the ability to develop anti-money laundering laws, which this is, and then they work with other governmental agencies. So one of the things about this is if you have a deal that's going to have FinCEN reporting, nothing is going to happen if it's money laundering, right? If it's a dirty deal, it's going to close. Nothing is going to stop it from closing as part of this reporting, because what happens is this data gets reported after close of escrow, right? That deal is going to close, and then the government's going to see what happened and then come back later, right? So this is not going to stop our transactions from moving forward from that perspective. The government isn't looking at them before we close. They're looking at them after we close. However, what could stop your transaction is your consumers not providing the data. All right. If they don't give the information that escrow needs in order to do the FinCEN reporting, escrow's not going to close. And the reason that's true is because escrow gets fined if they have a reportable transaction that they don't report. The fines are over $200,000 per transaction in an aggravated circumstance. So no escrow company is closing if they need to report and they can't get the data. So just know that. All right. So why do we think that real estate is a good place to look for money laundering? Because it is. Yeah, it's an easy way. Residential real estate in particular, which this rule covers only residential. I joke, like, what, you can't launder money in commercial? You can, right? You could launder money in commercial just as much as you can in residential, but a residential property is a much easier way to launder money than a commercial property. When you think about carrying costs and management and all those types of things, residential is a much easier move if that's what we're doing. And this is the thing. There's a lot of dirty money out there, right? There's money from drugs, and there's money from corruption, and there's money from, the mob. I don't care what it is, right? There's plenty of dirty money out there. If you can get it in, which is not always easy, by the way. Like, this is watching it happen. But so at one point, my background, I was an escrow officer before I became an attorney. And about 10, 15 years ago, California decriminalized cannabis, right? So we made it legal in California to own a dispensary and sell cannabis in regulated circumstances. Well, so escrow started happening related to cannabis. But escrow companies are regulated in a way that they couldn't take cannabis money into their accounts, right? So they weren't able to take the money, but we have these escrows. So as a lawyer, I was able to take the money, and so I was sub-escrowing, right? So I was working with escrow companies holding cannabis funds in order to do this. And on these deals, they'd be like, okay, I've got $1 million in cash, come get it. And I'd say, no, I can't take $1 million in cash any more than an escrow company can. You're gonna have to get it into my account. And it means we know that was dirty money, right? They got $1 million in cash, it's not in a bank. It's not grandma with her money under her mattress, right? This is dirty money from some illicit source. And so I was like, as long as you can get it in to my account, I can do the deal. I wasn't regulated in that way. I'm not monitoring it. And someone would have, it would end up in my account, right? They would get it into someone's bank account and it would get into my account, right? So that happens, right? It is absolutely doable. And then the thing is so it's sitting in that property, they hold it for a year or two, and they sell it. When they sell that property, it looks like the funds from every other escrow transaction. So there's no indication of that money laundering that happened. And so real estate's a really easy, good way to launder money. And the government figured that out. And so they've been regulating in this area, real estate in particular here in California, since 2016. So when we talk about FinCEN and government collection of data, it's actually been happening for 10 years, okay? So they do it currently, and there is what's called a geographic targeting order. Geographic targeting orders are specific orders issued by FinCEN covering certain specific geographic areas for 6-month periods, okay? We are currently under a geographic targeting order in LA County, right? We've been under one for like 8 years. So if you had a FinCEN transaction today, what would happen is the title company would show it as an exception on the title exceptions. It would be in the Schedule B. And then title would not close until they collect the data. That has been happening. But where this is going to shift is the amount of data that's being collected is going to grow exponentially when we hit March 1st. And the areas covered is going to grow exponentially. So today, under the geographic targeting orders, LA County is covered and 4 other counties in California. So most of the state is not covered under a geographic targeting order. And the current rule only applies to entities. Well, how many deals do you do where an entity is the buyer on your transaction? It's not common. Less than 2% of real estate in California transacts where the buyer's an entity. When we get to March 1st, it's not just entities, it's people taking title in a trust. How many people in California take title in a trust? 35%, right? So we went from 2% in a small little area to 35, 40% everywhere, anywhere in the US, right? So this rule is expanding significantly upon what we've been doing. The government has found this program to have some level of success, which is why it keeps growing. It started in 2016 in 2 places, New York City and Miami-Dade, Florida. Okay, if I'm looking for money laundering, am I in a good spot when I'm in Miami and New York, right? Bad guys, right? Dirty money, bad deals are happening in those places. It started with $1 million and $1.5 million all cash transactions, right? So that's how this thing started. It was successful, and it's grown since then. So the locations have expanded today until March 1st. So we've got 17 days. Through the next 17 days, it is 42 counties throughout the United States. Currently, to have a FinCEN transaction, it has to be $300,000 or more in consideration. What are we buying for less than $300,000? Not much, right? So, by the way, under the new rule, there's no threshold. So we don't even have to have consideration to have a reportable transaction. How do you have money laundering without any money? Right? You can have a no consideration transaction and they think it could be money laundering. This is the government, all right? I can't fix them. That's what we got, right? And then the instruments. Right now, we're looking for non-finance transactions. When we get to March 1st, their definition of financing is very limited. So like your hard money loans won't qualify to get them out of reporting. It's a very limited scope of lenders that'll qualify under the new rule to get them out. So I went through this. This is where we're at right now. We are going into this new world where we're going to be seeing a much larger amount of transactions being covered. If you've ever done a FinCEN deal, you'll find that the consumers are very annoyed by having to give their information to the government. I'll be honest, and I'm not a bad guy, right? Like I'm a lawyer. I was an escrow officer. I'm a notary. I've been fingerprinted and vetted. I'm not a bad guy. I don't want the government having my data, right? You don't have to be a bad guy to not want the government having your stuff. And in my real world, so my husband used to work for a government contractor. They made drones, the unmanned airplanes for the military. So he had security clearance. Well, to get security clearance, you got to give all your personal data to the government. And not only do you have to give all your personal data to your government, but your spouse has to give all their personal information to the government because they're worried you're going to tell your spouse stuff, right? So they got to make sure you're both not terrorists and, spies and all that fun stuff. So you know how you get those letters in the mail? We lost your stuff. Yeah, I got one of those from the federal government. Okay. The database where they maintained all the information from the security clearance applications was compromised. All right. So I don't want them having my stuff, right? They're not good shepherds of our data. Okay. So people don't like being asked for all this information. I can tell you as an escrow officer, one of the things you guys have done real estate deals, there's this form that escrow stands out called a statement of information, an SI, right? And it asks all kinds of personal information. How easy is it to get people to fill those out? It's almost impossible, right? We have a really hard time getting buyers and sellers to fill out a statement of information so that we can make sure there's no liens against the property, because that's what that's for, right? The title company is checking to see if there's any liens associated with that person's name or social security number that could impact the property. We have a hard time getting that data. And what happens is we don't get it till like right before close of escrow, and then we send it to title, and all of a sudden there's some child support lien or some tax lien, and now we can't close because we didn't have that to check because the consumers were reluctant to give us this information. We're going to have the same problem with this because if they don't give us the stuff, we're not closing. Now, it's not like an SI from the perspective of all of a sudden something's going to happen. We're just collecting it. Nothing's going to happen until after close of escrow when it comes to the government. So no one's going to stop the deal and say that as long as the data gets to escrow, we're going to close. But if it doesn't get to escrow, we're not closing, right? It is not going to close. So it will cause angst and frustration. I can promise you. Not only is it personal information, who's who is not particularly easy. You would think you'd know who's who. It's not as simple as you think. So under the rule, if you're an entity buying a piece of property, we collect the information about the entity, the name, the address, the identification number, right? So the ITIN or the tax ID number of the entity, all that data is collected. And then we have to collect information on what's called the beneficial owners, right? So the people who are the owners. Well, that's anyone who owns more than 25%. Well, what if no one owns more than 25%? What do we do then? Someone has to put their name on the form, right? And anyone who is in management and control, who can make decisions, could be a beneficial owner. So we could have people who don't own any of the company, but are beneficial owners under the rule, right? So the consumers are going to be trying to figure out who these people are to fill out this form, and then we got to collect all their personal information, right? So there's going to be questions and concerns, and that's an entity. The entity is easier than a trust, right? Who's the beneficial owner of a trust? There's like 7 different options on the new form. Like I have the form here. So this is the new reporting form, okay? You're going to start seeing this, and you're going to start seeing these questions. When we talk about beneficial owners, it's on page 2 here. A beneficial owner of a trust could be an individual trustee, an individual with authority to dispose of assets, the sole permissible recipient of trust income, blah, 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 blah. Who the hell is that? I'm an attorney, and I'm not sure I know the answer on most trusts, right? And when it's revocable, the answer is going to be different than when it's irrevocable, right? So we're going to have lots of questions and lots of confusion with the consumers. Oh, and you can be more than one, right? And on the form, it has a checkbox to deal with minors, because the way the rule is written, a lot of the people are minors, are children. Like my trust, my children are the beneficiaries of my trust. So if I were to die, they would be the ones who would have to fill out this form. Good luck. My 11-year-old, well, she would write something. I'm confident. And she would argue with whoever told her she had to fill out this form. I am confident as well. But that's the real world of this, right? Like this is not a simple thing. And again, where we were struggling to get data under the old rule, there's 111 data points that we're collecting under this rule. This is the actual report. This is what's collected on both the buyer and the seller's data is collected under this rule. Yes. Yep. So under the old rule, we were only collecting info on the buyer. Now we have to collect seller data as well. Yeah.
I'm just wondering if when the escrow owner has that, if there's harm, which there will be, I have no idea how to fill this out, can we refer them to you?
You definitely want to refer them to an attorney or a CPA to help them if they have questions. Neither the escrow nor the real estate agents should be giving them legal advice about who's who on this form, okay? Because it's complicated. And the answer will not be the same for any 2 deals, right? Each one will need an own individual analysis of who's who, okay? So what is happening with the data, just so that, again, you understand and you can talk to your consumers effectively, is it is getting into a database. Like I said, this has been happening for 10 years. This database already exists. It's just going to start getting a lot more data when we get to March 1st, right? What they're doing is they're using artificial intelligence. They're using AI to look at the data that comes in, to look for the suspicious persons, the numbers that they identify as problematic, the names, right? Then if a file gets flagged, it'll get given to an examiner. So an actual person will examine the file. If they believe it's money laundering, then it gets referred to law enforcement. FinCEN doesn't have its own police. So there's no FinCEN police who are going to show up. They're going to send the FBI or the CIA or the Secret Service, right? Some sort of big scary guy with a gun. It's going to show up if we have that. And it's happened. There's actually been high-profile arrests as a result of the program already, right? So it has happened. And what they do is, if they are able to identify a money laundering transaction, that property will get seized by the government and then ultimately sold, okay? So that's what happens with illicit funds. So there's actually a place you can go to buy all this stuff that got taken away from the bad guys if you've got extra funds. You'll get, there's Ferraris and houses and all kinds of like jewelry, right? Because that's where they hide the money, is in all this stuff, right? You send me an email, I'll get you the address. It's true, right? That's what they do. They auction it off. right? They auctioned all this illicitly bought stuff off. So this program has been going for 10 years, and it was audited by the Government Office of Accountability. So the federal government has a whole division that all they do is audit all the other governmental agencies. So the Government Office of Accountability audited the program, and they actually said it was doing horribly. They gave it an F. And it said, FinCEN lacked detailed documented procedures to direct the GTO's implementation and evaluation. So they said, you're getting this data, but you're not doing a good job of managing it. And it's true. And one of the things I would say, because today, right, under the GTOs, it's only 5 counties in California that are covered. Well, so I would say, look, if you're a bad guy, I live in Ventura County. Come on up, right? Like, you can do your money laundering in a property in Ventura County. No one's going to report it. No one's going to know, right? Which is why if a bad guy's paying any attention, it's very easy to avoid the current program. That's why the government was like, okay, double down, right? If it's not working because we have this limited scope, let's take away those limitations. And so Janet Yellen, who is the head of the Treasury, proposes an expansion of the program in February of 2024. So that's when this thing was proposed. It was approved in August of 2024 with an original implementation date of December 1st of 2025. So if this thing had gone under its original charter, we would be reporting today. It would already be happening. But what happened between August of 2024 and now was this thing called the government shutdown, right? So on September 30th of 2025, right, the day before the government shutdown, FinCEN said, hi guys, remember us? We got this new thing coming. Well, because we're gonna go on vacation for a little while, and we don't know how long, right? It ended up being 2 months, but they didn't know, right? And we were all still trying to figure out how to, like you saw this form, right? This is a lot of data to program. If I'm an escrow company, how am I going to collect all this data, right? So I created a form in order for them to figure out if it's a reportable transaction, because not every deal is covered, which is good. We don't want to do this on every deal, but then we have to know whether we have to report. The form I created just to figure out if it's a reportable transaction is 3 pages long. It takes 3 pages of questions to figure out if it's a reportable transaction, okay? Then we got to get all the buyer's data and all the seller's data. So this form, it's actually a PDF that you can upload into the government system. Well, I can't go get all the buyer's personal information on page 2 and then go send that same form to the seller and have them fill it out, right? I can't be sharing the data between the two sides. So I had to create a buyer data collection form and a seller data collection form so that escrow could get that data, and then they still have to compile it and put it into the system in order to get it to FinCEN. So this is a really heavy lift for escrow. Collecting, and by the way, I talk about it's 111 data points. So if I have a deal where my buyers are 2 entities, 50-50, Bob's LLC is buying half and Mary's LLC is buying half. Guess what? I need 2 of these, right? I have to see how this has this little plus signs on it? If you got more than 1 of something, you plus, and then you got to fill in that data multiple times. So it's not just even 111, right? It can multiply. Multiple buyers, multiple beneficial owners, multiple sellers, multiple properties, multiple deposits, it grows, right? So this is a heavy lift. By the way, escrow is going to be charging for this. They're not going to do this for free. So just know, if you have a reportable transaction, there's going to be an additional charge to the consumers for this additional reporting. The estimates it's going to average about 2 hours to do a report. Yeah. So it's a lot, right? And this is the thing, these are not data points, a lot of them, that are in our escrow softwares. So escrow companies use software. You guys all use some sort of software, your CMA program, your brokerage program. Escrow does the same thing, right? They have software that they use. These data fields don't even exist in the software. So it's not like they have a place where they can collect it, right? So they're having to figure out, which is why I created data forms, so they have a place to put the data to even then submit it, okay? So when this first starts, because it's coming, it's going to be really wonky. Don't blame your poor escrow company. It's going to be a challenge when this starts. Give us a couple months and it'll get worked out, right? It'll work and it'll flow and there will be a system but it's going to start really rough. Most of us are old enough to remember TRID when the government changed how we reported, and we were all scared to death of that new closing disclosure and all that. And it was wonky when we first started dealing with it. Having to explain that form and talk to people in ways we were never talking to them and dealing with them before was a challenge and a shift, but it's fine. It'll be fine. But just know, short term, we're going to have some challenges. So the government said, we know we're still not ready, and we're not going to be here to help you out. And so they gave us the extension to March 1st. So that's how we got to a March 1st implementation date. I see zero chance of it being extended again. All right, so I don't think we're going to get another extension. So what files are we reporting? So there are 3 criteria that we look at to determine if we have a reportable transaction. First, it has to be residential real estate, okay? So if you're doing commercial, if it's an apartment building with 5 or more units, it's not reportable. The one little wonky thing about residential is if it is vacant land, we would not consider vacant land a residential property. But the rule says if it's vacant land, you have to ask the buyer if they intend to build residential property on it. Yeah, and if they intend to build residential, then we have to report it if all the other criteria are met. Again, this is not a data point we have in our escrow software, right? We're going to have to be asking this question on vacant land to determine reportability. The presumption from escrow is we're assuming a file's reportable unless we can disqualify it, not the other way around. And the reason is if we over-report, if we make a mistake and we report something that wasn't reportable, the world keeps spinning and nothing happens. If we miss something and they catch us, we get fined. So we're gonna take the safety route of over-reporting versus under-reporting if there's a question, right? Yeah.
Is the form that you're doing specify that it's that question?
It does. And then, so one of the rule allows escrow to, because escrow is the mandatory reporter, not the consumers, right? Even though a lot of the data is consumer data that we wouldn't know if it's true or not. The rule says that we're allowed to rely on the information they provide to us as long as we don't know it's not true, and as long as they attest to it under penalty of perjury. So my checklist, in order to determine if it's a reportable transaction, has a place for them to certify, and then each of my data collection forms has a place for them to certify because they have to swear under penalty of perjury for us to be able to rely on it. Okay. So, yeah, go ahead.
Quick question. So, of course, if we're dealing with bad guys and they return this form all nicely filled out, how responsible are we to make sure that is absolutely accurate?
We're not, right? And that's important, right? It's not your job either as agents, right? If they give us data and we don't have a reason to believe that it's false, we can rely on it, okay? The reality is that they've caught bad guys who've filled out the forms. They got them off of forms. This is all self-reporting. So the bad guys do give us their data sometimes, or they'll lie, right? But that's not us. We're not responsible if they lie. As long as we can document that they gave it to us, we're not in a position to verify someone's tax ID number or do things like that. So that part's not on us. But so my story on this, again, most of us remember 07, 08, with the mortgage meltdown, right? And what happened was a lot of properties became underwater, right? They owed more money on them than they were worth. And what happened was the lenders agreed to short sell them. Remember? Short sells. We don't do a lot of them today, but we did a lot of them. in 07, 08. And one of the documents, if you had a short sale, was a form called an arm's length affidavit. You guys remember that form? So that form specifically said, I, buyer, am buying this on a short sale, and I'm not related to the seller, right? And the reason they did that is they didn't want families cheating the lender out of money, right? So they had to certify. So I'm an escrow officer when this is happening, right? And I'm signing a set of loan documents, and the woman there is like, yeah, I'm buying Uncle Henry's property, right? And I'm like, you're not buying Uncle Henry's property anymore, because I now would be in that conspiracy, because now I know that you lied on that form. If I didn't know, I send it in. You buy Uncle Henry's property, it's your problem. But now it's my problem if I knowingly allow that to move forward. So I had to resign from that escrow. So that's where escrow's in that position. If they tell us something that doesn't make sense or doesn't match up, I'm not going to build residential, and we know they have permits to build a house, right? We can't just send it in. Where I'm nervous about this is we got to figure out who these beneficial owners are. So if we're looking at an operating agreement for an LLC, and it says something like who owns what, right? And then they give us this form and they don't match. Now we're in a very challenging position, because what the operating agreement says doesn't match what they gave us. So now we got to call them. So I'm telling escrow not to. But if they do, if they see it, now they're stuck, right? So one of the things I'm actually encouraging, so this is a challenging area, and escrows walks the line of practicing law a lot in what they do. They draft documents, which is traditionally a job for a lawyer. They review documents, they figure out who the signers are. All that kind of stuff is stuff we do, and we're walking that line, right? So I'm encouraging them not to get the trusts and the LLC agreements, the operating agreements, in their escrows. The title company is going to want them. And I'm like, okay, send them to the title company, but don't send them to us, because if we have them and we're analyzing them and then there's a challenge, now we can't close that deal, right? So, but it's going to be a learning experience as we're getting used to this and dealing with this, okay? So again, there are 3 criteria if it's reportable, and they all have to be present. 1, it has to be residential. So if it's not residential, I don't care who the buyer is. I don't care if they're getting a loan. We don't report. If the buyer is a person, a physical person, or multiple physical people, we don't report no matter what. If it's residential, if they're getting a loan, as long as there's no entity or trust buying, it's not reportable. The third one, the financing, if we are working with an anti-money laundering regulated lender, so NMLS, FDIC, or NCUA, right? So big lenders. Then we get out under the lender. If not, the loan won't get us out of reporting. So those are the 3 criteria that are going to decide whether we have a reportable transaction. If we have a reportable transaction, those 111 data points are what's collected. The reporter, the person who has to report, their data is collected. The property information, so the address, and the legal description. The first 1,000 characters of the legal description. We're going to be typing a lot of freaking legal descriptions into government forms, right? Then the buyer trust or entity, its name, its address, its tax ID number. Then the beneficial owners of the buyer entity or trust, their name, address, tax ID numbers. The seller's information, if the seller's a trust, the trustees of the seller's trust, the purchase price, and all the deposits. So average escrow has 3 to 4 deposits that come in, right? The initial deposit, maybe some money in the middle, like mom and dad are lending them some money. We got the final funds that come into escrow, and then they get a loan or maybe a second, right? Every one of those deposits, all the information about those transactions, where it came from, what bank, what account number, who the name on the account holder is, all that data is collected, all right? So that's a heavy lift on escrow on the back end. In particular here in Southern California, most escrows are done by independent escrow companies like Proactive, right? They work with the title company. And so like here, Stewart, right? The title company gets the lender's money. The lender funds to the title company, not to the escrow company. And then the lender does the payoffs, okay? So that money, escrow is the mandatory reporter, but the money's going to title. So escrow is going to have to get the info from title in order to put it into the report to give it to the government, right? So it's going to take a lot of collaboration between all of our different service providers to make this work, okay? And like I said, the threshold where today it's $300,000, that goes away when we get to March 1st. There's no threshold. We do not have to have consideration. And not only are escrow mandatory reporters, attorneys are mandatory reporters under this rule. If you prepare a deed, you are required to determine if it's reportable. So again, attorneys, I do deeds. I form LLCs and I put properties into entities. I would have to report if the criteria were met on that transaction, even though there's no money, right? It's just them creating their own thing. The one little carve out is for trusts, right? So estate planning attorneys, right? We create estate plans and then we put their properties into their trust. That's called funding, by the way. One of the things we see often is people will go create this beautiful trust. They'll spend a bunch of money on a trust and then they never fund it. So they never put their property in the trust, right? For the trust to control your real estate, it has to go in the trust, right? So that deed, taking it from you to your trust, is not reportable if it's you, right? If you created the trust and you're putting your property in your trust, then it's not reportable. But any other deal where the property's going into a trust, so any sale that you guys are handling, right? That deed is going to be from a seller to the buyer's trust. That's a reportable transaction if the other criteria are met, okay? So I'm not going to go into this in detail. I kind of mentioned it. Residential has a couple of wonky things. What we consider residential 1 to 4 is in there, but where we have some interesting things I talked about, the vacant land, co-ops are covered too. Are there any co-ops in this area? There's some in LA, but not a lot here. So in a co-op, you own stock. You actually don't own land. Those are covered under the rule. And mixed use. You probably do have mixed use here. If it's mixed use and it has less than 4 residential units, it's covered under the rule, okay? As far as financing, again, any all cash, any seller carryback, any hard money, private lender, mom and dad giving them money, all of that would not get us out of reporting. We're only dealing with a bank that's a mandatory reporter under the Bank Secrecy Act. That'll get us out from a financing perspective. A couple of other caveats on financing. The property that is being bought or escrowed has to be the property that the loan is related to. So we often see people borrowing money from a property they already own and using that to buy another property, right? So they borrowed money, but that doesn't get them out because that money isn't related to the new property. They actually have to get financing related to that property. And the lender has to vet everybody who's going on title. So if we have multiple people going on title, but only one of them is getting vetted for the loan, like a non-borrowing spouse, right? That would not get us out because the anti-money laundering vetting hasn't happened against all of the people going on title, okay? So those are some of the weird little caveats with financing. So one of the things we're going to have to do as escrow is figure out whether the loan's going to get us out or not, right? So there's a website that you can go to see if a lender is regulated and will get us out. It's the Federal Financial Institutions Council, FFIEC. You can go to their website and look up a lender. One of the things that I think is going to be a challenge, right? So I'm encouraging escrow when they open escrow to do the determination of whether a file needs to be reported because we got to collect data and the consumers need time to do that. And we don't want this holding up escrow. But what happens if they sign the purchase agreement one way and then a week later they change their mind? Maybe we need to add someone on title to qualify for the loan, or we need to take someone off of title to qualify for the loan, or we decide we want to put it in our trust, or we decide it will be better if it's in my entity instead of my name, right? So one of the things is it could change during the course of the transaction. Not only could it change because of who's buying, it could change because of the lender. If we're working with a mortgage broker, we don't know who the actual lender is sometimes until we get loan documents. So it could change. And all of a sudden, we didn't think we had a reportable transaction, and now we do. Or they didn't qualify for the loan, and now we have to get into a new lender who's not an anti-money laundering regulated lender. So just know these are things. I'm like, escrow, look at it up front, but look at it again. You can't just assume when you originally checked it, you have to look at it twice, right, before we close and make sure nothing has changed to make it reportable. So when we're talking about who's covered, if it's not a human being, it's a covered transaction. Their definition of entity is corporations, limited liability companies, partnerships, or other legal vehicles commonly used to hold title. That's a super broad. If it's not a person, it's reportable, okay? And then when it comes to trusts, there is a list of exemptions. If you're a bank, you're exempt. If you're a governmental agency, you're exempt. Our escrows are not, we're not selling properties where they're the buyers. It's going to be a very rare, but there is a list, I will admit, but it's not going to happen much. As far as trusts, revocable or irrevocable, foreign or domestic, doesn't matter, right? So we're not getting out if it's not a person. There's a couple of exemptions for the trusts, but they're tricky because if the trust gets you out, you're not out. You're just now an entity because you're still not a person. Okay? So the trust exemptions don't get you out. They just take you to entity instead of person. And that just changes who the beneficial owners are on the reporting. Okay? There are a handful of transaction types that are exempt just in and of themselves. So if we're doing an easement deed, right? An easement is a right to use someone else's property. That's exempt. Because the deed, understand, the deed is the trigger for reporting. Okay? So any sort of title transfer is what's going to trigger it. So if we're transferring because of a death, it's exempt. But that's misleading as well because it's not mom died and the heirs are selling the house to a third party. It's mom died and we got to get title into the name of the heirs, right? Some sort of affidavit or some sort of probate document, right? That transfer to the heir is not reportable. But when the heir sells it, when you do that sale, that is reportable, okay? Bankruptcy, so if we're doing a sale as a result of a bankruptcy, a court-ordered sale, right, which can happen. One of the questions I've gotten is a probate out? So probates in California are court-supervised, but they're not court-ordered, okay? The court isn't ordering that sale. They're just watching that sale. So I would take the position that a probate would not get you out, okay? Divorce, again, it's not we're selling the house to a third party because we're getting a divorce. It's the transfers between the spouses that gets us out under divorce, all right? The one I talked about for the trust, if you're putting a property into your own trust, it's exempt. A transfer to a qualified intermediary, which is very rare. We do exchanges, right? Qualified intermediaries, but we direct deed. We don't deed to the intermediary, so that doesn't get us out. And then the one that scares me by far the most is where there's no reporting person. So when is that? When someone does it themselves. We do not want people doing their own deeds, I promise you. It goes very badly. I've had to deal with this in the real world. Have you guys heard of this thing called a transfer upon death deed? Right? So California created a document, it's been about 8 years now, that it's designed to avoid the need for a trust, right? So it's poor man's trust, avoiding the cost of us big, expensive attorneys, right? It allows you to record a deed that says, when I die, this person gets my property, right? So it's a do-it-yourself. So people do it themselves. You know how often they're enforceable? Almost never, because they do it themselves and they don't know what they're doing. So I got hired by a family that mom on her deathbed, right? Mom gets in a car accident. She's dying. She wants her son, who's living with her, to get the house because she's worried about him being taken care of. She signs this transfer upon death deed in the hospital. She dies, right? And then the son's trying to enforce it. Well, it doesn't have an APN number. It doesn't have a legal description, right? And the title company's worried, did mom have capacity, right? Because she's on her deathbed. So no title company will insure this thing, right? The sister who got disinherited, right, is fine with it. She was there at the hospital. She knows what mom wanted. She's not fighting it. So I literally had to go to court and I had to go get the court to affirm that deed and correct it so that those poor people he could get the house and sell it. Because of course that's what he did, because he's the deadbeat son who isn't going to like use what mom, she's just going to blow the money, but that's not my problem. You know, we all know him, right? But so he spent $5,000 on me going to probate court, which the whole point was to avoid probate, because they don't know what they're doing. No one had any ill intentions. They don't know what they're doing. So we don't want them doing their own deeds, promise you. And the title companies really don't, right? You guys all know when they have a deed that's not recorded by a title company, they get all wonky. They're worried, right? We get these uninsured deed affidavits, right? Well, when our deed is with a dead person, it's really hard to get an affidavit out of them, right? And if you do, you probably even have more concerns, right? So this is an area of concern for people like me, that people are going to try to do this themselves, right? And we're going to have a lot of stuff we have to clean up. Look, we all talk about LegalZoom, right? And it's, it's a service, and I'm not anti-LegalZoom. They bring me a ton of business because they do it wrong. And then you have to hire me to fix it, right? So not anti-LegalZoom or that. But the reality is most of us aren't in a position to do this ourselves, right? So you had a question?
Yeah, I just had a question about all this information you're giving us. So the timeline, should we, right when you open escrow, you start obtaining this information?
Yes.
Because I know that you have to report this before the end of the month. You don't have to, you actually do it after, but my policy, my companies are going to be during the escrow.
So you can't report it until it closes, okay? So what will happen is the rule, and I don't know, I've done this presentation a lot, so I can't tell you which slides are in this deck, but the rule says that you have until the end of the month following the month that escrow closes to report. So you could close, if you close today, right? Well, so if you close March 1st, you could report March 1st, right? But you don't have to report until April 30th for anything that closed March 1st.
However, just from my experience, it's hard to get these people to cooperate with you.
I'm going to tell escrow, you're not closing until you have the data.
But is there
So
anything that escrow would have to say if you don't close that, if you don't give me this information, I can't close?
yes, so a couple things. The one, I haven't gotten to it yet. It's in the slides. There's a car form for this,
Okay, I'll wait.
right? And two, I'm encouraging escrow companies to put language in their general provisions that specifically allows them to resign if someone won't provide the data. They could do it anyways, just as a general rule. Contracts require consent. So if escrow doesn't get the data, they can walk away, right? They can't force them to give them the data. They can choose not to move forward if they don't get the data. That's just legally their right. But I like having it in writing. So a general provision is what I'm encouraging escrow companies to have. General provisions differ from escrow instructions. Escrow instructions are mutually agreeable, right? The parties agree to any instruction we have. The general provisions are like playbook of how we do escrow. They're not optional, right? They're mandatory things. So like 1099s, escrow reports for the IRS on every escrow that closes. That's not optional. So it's not an escrow instruction that we're doing the 1099. It's a general provision, okay? So same thing here. This is not optional reporting. So it's a GP. It's not an escrow instruction, okay? So one more type of deed that is out is a corrective deed. So if a deed got recorded and it had a typo, a clerical error, and it gets corrected, that's not a new transfer, right? So that doesn't get reported. So this is the government portal, right? All this stuff is going into a government database, and that's how you get in. That's the front door. So BSA, Bank Secrecy Act, that's what this is talking about. And what they got to do is they have to do what's called an e-filing. So they have to either upload this PDF form, or they have to go in and get into the database. You have to give your data. You got to get a key, right? So in order to be able to submit data in the system, you have to set up an account. And you have to give them all your personal information to set up the account. Once they set up an account, then they can do the reporting. And they can upload the form, or they can manually enter the data. Or like a big company can do what's called a batch filing, where they can collect a bunch of them and send them all in at once. So those are the different ways. from your perspective as real estate agents, this isn't all going to be done the same way. All right. So some companies are going to use my forms, and that's how they're going to ask for the data. Some companies are going to work with the title company, and you'll be talking to the title company instead of the escrow company. And some companies are using, there's different online portals that have been created. So some companies may just send you a link to fill in your data on the online portal. None of them are wrong. All right. So, because it's not all going to be done consistently. So there's going to be confusion as what's the right way to do it. There's no right way. As long as we collect the data and get it in, we've done what we need to do, but it's going to happen in different ways. So just, you won't know how it's going to happen on any given deal until you're in that deal. This is their, who's the responsible reporter? The escrow company is the mandatory reporter. Under the current rule, it's the title company. This one, it's the settlement agent. So it's escrow when, like I said, the data is going to get collected before we close, but it's going to FinCEN after we close. Okay. And then it's our 111 data points multiplied as necessary to complete any given report. So that's our form. That's what we're doing. Any field that is yellow or has a red asterisk is mandatory, right? So the government portal will not accept it without those fields filled in. The gray ones come up depending on how they answer the questions. So for example, it asks if the buyer is an entity or trust. If the buyer's a trust, then we put the date of the trust. That field is gray because if there's no trust, then that field never gets filled in. So just so you know, there's weird questions on this that don't make sense depending upon how you answer. On page 1, my favorite question, number 3 on page 1, note to FinCEN. What the hell are we talking to FinCEN about? So what's your role as a real estate agent? You just want to be able to talk intelligently to your clients about what this is and why it's happening and encourage them to cooperate. I'm nervous that agents are going to be like, I don't know what escrow's talking about. I'll talk to them, right? You know how it is, right? I'm not making this up, right? Oh, that escrow company's crazy. Don't listen to them. We'll just move it to another escrow company, right? I'm telling you, that happens. So the more that you understand and are encouraging, and I'm going to say, figure out whether it's reportable from the start. Like when you're signing the purchase agreement and when you're doing the list, have that conversation. In a multiple offer situation, let's talk about this. What if we have a multiple offer situation and 3 of our buyers are individuals and one's an entity and one's a trust? Can I, as a seller, say, I don't want the government getting my data, so I'm not going to pick one of those buyers that's an entity or a trust? Can a seller discriminate against an entity or trust? What do you think? It's not, because it's not a protected class, right? So fair housing is about protected classes, and being an entity or a trust isn't protected. It's not because of the color of your skin or your gender, right? So you could. But like I said, even if we did that, it could change somewhere in the middle of a transaction. And the purchase agreement allows them to do that under certain circumstances without seller consent. But it's something that you guys as agents should be knowledgeable and talking to them about of, okay, we've got these buyers, just know if we accept this one, this is going to happen, right? It needs to be part of that conversation, okay? All right, that's my slides. So good luck. Your escrow companies, your title companies, I will be here. You can reach out to our office if you have questions. General information we will give. Deal-specific information is what we get paid to do. So we won't be able to give you free advice on any particular deal, but general rules, guidelines, questions, free to help. Okay, so thank you guys.
Thank you. Well, I hope that was very informative.
I do have a quick question.
Yeah.
Okay, so I get it. Escrow, every transaction going through escrow is required to report that. Say it's accommodation.
Yeah.
After we close, that's title.
So
Report that.
if escrow drafts a document as an accommodation, they would be a mandatory reporter, or if title drafts a document as an accommodator, they would be a mandatory reporter. If title or escrow, or like our firm, we're an authorized recorder, right? So law firms can record documents. They never go to the recorder's office, right? So we would be mandatory reporters if we record something. So I think a lot less accommodations are going to happen is the short answer. The title and escrow companies are going to be much more concerned about their risk. It was never a great idea, in my humble opinion, to do accommodations, but now it becomes a much higher liability. So I'm going to encourage, send them to an attorney, send them to a doc preparer, send them to someone who can manage it, because they're not going to be in a hurry to do accommodations. Okay. We do deeds. Yes. So, all right.
Any more questions?
The county is not a mandatory reporter, but it's someone who takes it to the county. So they could take it themselves, but again, if someone prepared it besides them, that person would also be a reporter, right? So they're trying to catch it at 7 different levels in the list, right? So really, the only way to get out is to do it yourself. Okay. Yeah.
So you said non-finance, so if it's like entity involved, but it is going through financing, then it doesn't apply.
Yeah, if they're getting a traditional loan, it would not be reported, right? And so again, when you're talking about that, most lenders aren't lending to an entity, right? So what happens is they'll take title in their name and then they'll go transfer it after escrow, right? That's common. Even with trusts, right? A lot of lenders don't want to lend to a trust, so the people will take title in their own name and then go put it in their trust after close of escrow. Then the escrow is not going to report. But if someone prepared that deed, that person would be a reporter, maybe. So there is this weird little gray area, right? So if I'm a buyer and I buy in my own name, escrow is not going to report. Then I go to my trust and estate attorney and put it into my trust. That they're not going to report either. So you can get out of reporting if you do your transfers in a 2-stage process. We are not encouraging this behavior, but there is a little loophole, but only for trusts. It doesn't work for entities. Okay. All right. Great. Well, thank you guys for coming out. Appreciate it.